Tactics that insurance companies use to minimize payouts and how to avoid their common tricks. I'm Joel, this is Jared. Those are the topics we're going to cover today. So Jared, you want to get us started with number one?
Yeah, so the first thing I think all insurance companies go for are trying to make a premature offer early on in the case. They try to get to you shortly after, as soon as they learn that the crash happened, and try to make an offer to get you to go ahead and accept before you really understand the value of your case or maybe even the seriousness of your injuries.
Yeah, I kind of look at it like, say you're in a wreck on Monday, you don't feel terrible, but you don't feel great. You go home, try to sleep it off. The next day you're a little worse. The next day you're a little worse. The next day you're a little worse. But you're trying to avoid going to the doctor, and then all of a sudden on Friday, the insurance company calls you up and says, hey, we're so sorry you were in a wreck. We're going to pay you $1,000 that you can use towards medical bills. We're going to give you another $1,000 just for the inconvenience and pain and suffering. And then a week later, you're in unbearable pain after having accepted that $2,000. And you go to the doctor and they say, hey, we need an MRI. And that MRI is going to cost $5,000. And you're in the situation of wondering, well, who's going to pay for this? But the insurance company's really happy because they just saved themselves a ton of money by paying you too early instead of waiting to see how badly you're hurt and what your bills are going to be. I would say the second thing that they like to do is dig into claims history. So if you have a history of making insurance claims, there's a database, and all insurance companies have access to that. So every time you make a property damage claim, a bodily injury claim, there's going to be a record of that. So they're going to look into it. And if they see a lot of claims, then they're more likely to offer you less because they're going to think, well, this person's habitual claims maker. I don't know if that's the right word for it, but they do it a lot, and so they're going to question the validity of your claim, even though it is legit if you have a long claims history.
Yeah, and along that same line, the third thing I think we see a lot of is looking at your pre-existing medical history. Mm-hmm. Same as the claims history. They will go, and when you do make a claim, not only does it show that you made the claim, but it also shows what body parts you claimed were injured and which medical providers you went to and what the case settled for. So the insurance company will rely on that information to maybe convince a jury down the line that this crash is not what caused those injuries, that they were actually pre-existing from a prior crash, which you made a claim for, and try to use all of that information together to either make it seem like you weren't injured or to really reduce the value by suggesting that the injuries you're complaining of weren't related to the current wreck, but instead something that happened in your past.
Yep. Number 4 is, depending on what state you're in, lots of times states will have what we call the collateral source rule. And that means the liability insurance company does not get the benefit of you having health insurance or you having some type of program to pay for your medical bills, right? They're responsible for the entire amount of your medical bills. But a lot of people don't know this, and the insurance company will call them up and say, hey, we're going to pay you $1,000, and then we'll pay all your reasonable out-of-pocket medical expenses. That is a huge trap, especially if you're in a state that has a collateral source rule, because two things there. Number one, they're going to say reasonable, and their idea of what a reasonable medical bill is may be completely different than what the hospital, doctor, or you believe is reasonable for your medical bills. And then number two, they're trying to avoid paying the sticker price for the medical bills and only pay what you're actually out of pocket, which that's not fair to you because you pay the premiums to have the health insurance and you pay the cost to have this coverage. So why should the insurance company get the benefit of you spending thousands and thousands of dollars over the years to have health insurance? So don't fall for that trap.
That brings us to number 5, which Joel touched on a little bit before, but that is that insurance company will often contest the reasonableness of your medical bills. So despite whether you have health insurance or say you don't have health insurance, regardless, the insurance company will present you with their argument, which is that your bills were just too expensive, which is crazy because we all know that if you get in a wreck and you call 911, you're not going to ask the ambulance how much they're going to charge you to drive you to the hospital or try to get a pricing guide for what Grady Hospital is going to charge you when you get there. You're just mainly focused on getting the care you need to feel better. And oftentimes you're also going to owe that money. So despite an insurance company telling you that it costs too much, that doesn't mean that you as the injured victim aren't going to have to pay that bill. And sometimes they'll even go a step further by hiring a billing expert to come in, and the billing expert will testify based on his expert opinion that the bills cost too much money. But again, while they might say there's a basis for it, common sense would tell you that there's not, because you're not out shopping for emergency care. You know, you're kind of left with the ambulance that shows up and the hospital that they take you to. So again, the insurance company will make it seem like it's right to say those bills cost too much money, but ultimately you as the victim are still going to have to pay.
Yeah, and those experts are usually trying to pick out insurance companies or government programs that pay very little on medical bills, like Medicaid or Medicare or something like that. And they'll say, well, look, Medicaid only pays $10 for this $100 bill, so that's reasonable. But it's not as simple as that. There's all kinds of programs and funding issues that go into the hospital's decision of what they're going to accept, how much they're going to accept, and all that. So the insurance companies will spend a lot of money on experts sometimes to try to make it seem like your medical provider is charging some astronomical, unreasonable figure for the medical treatment they provide to you. The next thing that I think we should talk about is, and this would be number 6, is the time that it takes you to get treatment. So we talked about a little bit earlier waiting a few days to go to the hospital. Sometimes that's completely reasonable, especially if you're just a little sore, you feel a little banged up, but sometimes that pain doesn't go away. And when it doesn't go away, it's entirely reasonable to go back to the hospital. But if you don't go back to see a doctor, an urgent care, a physician, or a hospital, or anything for more than 2, 3, 4 weeks, then the insurance company is going to have all kinds of arguments about, well, it must not have been that bad, or you would have went to the doctor sooner, or how do we know that something else didn't happen in the interim that injured you? You just waited too long. And even if you really were hurt in the wreck, they may even say, you know what? By waiting to go to the doctor, you made yourself that much worse because the doctor couldn't get in and treat you soon. So if you have a suspicion that you're hurting, if you're in pain after a wreck, after a fall, it's better to at least go to a doctor, even if it's only in urgent care, to get checked out and have it documented that you're complaining of pain there. Because it's one thing for you to say I was hurting, it's another thing to go to a doctor or medical professional and have them document that you were hurting, that they did the testing, they did the imaging, whatever, to show that you actually had injuries.
Yeah, my favorite line of questioning, ridiculous questioning from a defense lawyer, often goes something along the lines of, well, Joel, what do you do when you break a bone, or if you get the flu, where do you go? And obviously the answer is the doctor, and then they turn it back on you to say, but you didn't go to the doctor here, obviously creating that, I guess, assumption that maybe you weren't really that injured.
Yeah.
And along those same lines, taking us to number 7, and we talked about this before with billing experts, but insurance companies will also hire other types of experts to try to diminish your claim in other ways. One of which is they will try to request that you get an independent medical examination, which is where you go to a doctor or physician of their choosing to get an examination for them to decide whether your doctor is right in saying that you were injured.
Yeah, and the independent portion of that phrase is the biggest misnomer I've ever heard.
I was just about to say, you can imagine where the insurance companies, how they select these people, but generally those don't go well. I don't know that I've ever seen an IME where they actually say, oh yeah, everybody's right, you were injured. Another type of expert would be a biomechanical engineer. They will hire these experts to come in and look at the forces caused by the wreck in conjunction with accident reconstructionists. They will kind of put together how the wreck happened and make some opinions about the forces caused by the wreck. And then usually those results indicate that, according to them, there's no way you possibly could have been injured as a result of the collision here. Joel, I know you've had some interesting opinions from some experts on how not to be injured in a car wreck.
Yeah, the overall arching thing, I think, at least for purposes of this video, is they will spend tens of thousands of dollars on these highly educated experts who review tens of thousands of cases for insurance companies over the years, and they get paid millions and millions of dollars. And let me tell you something, the almighty dollar will trump ethics every day of the week, especially when you're in the business of telling people what they want to hear. And the insurance companies want to hear, you know what, there's less than 1% chance that Jared could have sustained a brain injury in this wreck. So they will come up with all kinds of studies, they'll stage them how they want to, and throw the scientific method out the window to come in and say, you know what, we've done all these measurements, we've done all this testing, there's less than a 5% chance that you could sustain this type of injury in this wreck. So it's more likely than not that you were not hurt. So they go to extremes, especially when it comes to things like brain injuries or spinal cord injuries, things that you can't see like a broken bone, because nobody could come in and say when you've got a bone sticking out of your arm that this wreck didn't cause that. So they try to attack it from other types of injuries, and they're very selective about the cases they use it in, but just be aware that that's something that they do. The next, number 8, that we want to go over with you is when the person that hits you, if it's a car wreck case, doesn't have any insurance or doesn't have enough liability insurance to cover your damages, and then you're making a claim against your own insurance policy, which we call uninsured or underinsured motorist coverage. The way that that works is you prove that the liability carrier, the at-fault driver, does not have enough insurance to cover your damages. Let's just say they've got $25,000 of coverage, you've got $100,000 in medical bills. Obviously, they don't have enough insurance to cover your damages. So you look to your insurance company to make up the difference. If you can't agree with your own insurance company as to what they should pay you, they will actually hire a law firm to defend the case against you. And in the state of Georgia, they're going to defend the case in the name of the person that hit you. So if Jared hit me and then he has 25 of insurance coverage, I've got 100 of bills, and then I've got, say, USAA for UM coverage, then I would have to sue Jared, and then my own insurance company would step into Jared's shoes and defend the case in his name. So it would look like Joel versus Jared, when it's really Joel versus his own insurance company, USAA. And I'm just using USAA as an example because it's the first one that came to mind. But they will hire law firms to defend the case against you, and you can't even, at least in Georgia, you can't even tell the jury what they're doing. So it looks like person versus person instead of person versus insurance company.
Yeah. Moving on to number 9, another tactic the insurance companies will use is surveillance, especially in larger claims where there's more at stake. The insurance companies very well might hire a private investigator to surveil you as you go through your day. They'll literally spend thousands of dollars to pay someone to spend entire weekends sitting outside your house, following you where you go, filming every move that you make, just hoping that they can get something on video that will either, one, show you're not injured or contradict something you have said at some other point in the case, spending tons of money and time just to find that one little piece of something that they hope will be damaging enough to the claim that could either make it where you don't recover or definitely decrease the value of the claim.
Yeah, and it's so obvious when they've done that, and especially if you're in a deposition and the defense lawyer starts asking you questions like, can you play basketball anymore? Can you mow your grass anymore? Can you change the oil in your car? These are all things that could easily be videotaped from across the street, and if you say no, then they catch you on a line. It's not even, the biggest deal is not that, okay, you can play basketball. The biggest deal is that you're dishonest about it. So they're just trying to catch you in anything that could show that you're being dishonest, which sort of leads us to the next point, and that's they will research your social media, whether it's Facebook, Instagram, X, TikTok, whatever else is out there, Snapchat. I can't remember. I'll ask my daughter, she could tell you. But any of the social media platforms that are out there, YouTube, we're on it right now. If they can find you doing something, even if it's relatively innocent, that you say you can't do in testimony or in a recorded statement, they will then turn around and use that against you later to try to discredit you and make you seem like you're being less than truthful.
And not only just in statements or depositions, I've actually had some insurance adjusters match up doctor visits notes with the timeline on Facebook and literally go, date by date of service and looking at what my client was telling the physical therapist about what she could and could not do, then look for pictures on social media that contradicted the statements made about back pain, neck pain, I can't lift, this or that. So they really put in, it's almost the modern day surveillance. They don't have to do as much surveillance anymore because our clients tend to post we all tend to post a lot of things, and it makes it a lot easier for them. They've got dates, timestamps, everything they need to just go through and really match up to make sure the testimony is consistent. And again, it's not about whether you can or can't lift 10 pounds. It's more about, are you truthful in what you're saying as the case goes along and the credibility that you have as a client. And then finally, number 11, the last tactic we're going to talk about today is delay. I think insurance companies are great at delaying cases, and because in Georgia, we have a 2-year statute of limitations. If you're going to file suit against the defendant to recover, save some rare technicalities, you have 2 years to do so. So if an insurance company can kind of nice guy you and tell you, yeah, we'll get to it, we'll pay it, they can kind of drag the case out, hoping that maybe you don't reach out to an attorney or you don't take the steps necessary to preserve the claim. And once that 2 years passes and the statute runs, then they're not legally obligated to pay you anything because you no longer can bring that claim.
Yep. And they even do that once a lawsuit's been filed, right? So make no mistake, yes, insurance companies have bank accounts, and yes, they have money in bank accounts, but the vast majority of insurance company assets are spread out across the market. They may have money in oil, they may have money in banks, they may have money in mineral rights, they may have money in investments in pharmaceuticals and all across the board. And so when they know that their money is either stretched thin because the market's down, or they know that they're making a killing off of the money that they have invested because the market's surging, they may try to delay and delay and delay because the money that they have is in those investments and it's making them money. And when you're talking about a company that's got as much money as a major insurance company, their millions and billions of dollars, the interest that they gain on that in one day would pay for your entire claim and many other claims in most cases. So it is not in their best interest to pay you immediately, except for in those situations that we talked about at the beginning of this video, where they may call and offer $1,000 or $2,000 to try to make you go away soon. But if you've got a substantial claim, they will try to delay it as long as possible. So that's why it's important to take steps to be urgent, to be efficient, and be thorough to move towards trial, because ultimately, if you can't come to a settlement agreement, the only people that can make them pay you the fair amount would be a jury, and that would mean going through all of the different steps that you need to go through to get to a jury trial. So, any other things that we need to talk about?
No, I think we've covered it.
All right. Well, we hope this video has been helpful to you. If so, give us a thumbs up. Hit that subscribe button. Otherwise, we will see you next week. As personal injury lawyers, we love what we do, and we're happy to share the experience that we've gained in personal injury law. To help our family, friends, and YouTube subscribers, we've shared over 300 personal injury videos covering various injury topics. So if you'd like to gain more knowledge that may help protect yourself or a loved one when they're on the roads or out in public, check out our channel or view our playlist of shorts for quick personal injury tips.